Good morning, everyone. My name is Simon Cathro. Next to me is Mark Wilson from W Advisors. This is the first webinar session for the new Cathro Partners firm that was set up in August this year. Thank you for those that signed in and people signing in now as we speak. Today's presentation, we're talking about Safe Harbour. We thought it was a relevant point at this point in the juncture as we're coming out of COVID and the various government support packages that have been in place now for at least 18 months. With respect to the presentation will go for about an hour, a little bit over an hour, so we won't be finishing at 12 o'clock, we're finishing just after 11. If you have any questions, please just put that into the chat box. We'll try and attempt to answer all the questions. And we'll get straight into the presentation now. Just a bit of background just in terms of my firm. The firm was set up in August. We specialise in restructuring, insolvency and turnaround, and advisory services that are linked to those service offerings. Mark's, do you want to talk a little bit about your firm and just a bit of background there?
Thanks, Simon. Yeah, we've a small boutique corporate and dispute resolution firm based in the city. We do corporate, commercial, insolvency and litigation.
Great, thanks, Mark. And Mark and I have known each other for a few years now and done a few bits and pieces together. And so we thought it would be useful just to talk a bit about Safe Harbour. And get those online to better understand what it is and whether it's something particularly for those accountants and lawyers that have clients that may be experiencing financial difficulty at this stage. So, Kira, if you can just move on to the next slide, we'll get straight into the presentation. So just in terms of the agenda, we've got 5 parts to it. We'll just set out firstly a bit of a brief outline as to what is Safe Harbour. The second part we'll talk about is when does a client consider using the Safe Harbour provisions. The third section will be around how is a Safe Harbour engagement structured. We'll talk a bit about what the different approaches can be used for Safe Harbour, and then we'll finish off with whether the actual Safe Harbour provisions have been a success. For those that are in the insolvency and restructuring space, there is a review going on around the Safe Harbour laws at the moment. There's been some submissions put in that regard. So we'll touch a little bit on some of the feedback that we've undertaken by some of our association representatives, being TMA and RETA, in that perspective, and we'll get a bit of an outline as to what the members see as whether it's been a success, and it'll be interesting to see what comes back from the government review. So we can just move into the next slide, Kira, please. So what is Safe Harbour? So this is a mechanism that basically is available to directors under 588 GA. It was introduced to basically provide a new and alternative option to directors with respect to a company that may be in financial stress. The whole purpose of Safe Harbour was to create a new option for the directors and its company to look at restructuring a business without the need of putting it either into administration or liquidation. It's probably arguable and generally agree that we have very tough insolvent trading laws here in Australia as compared to other countries. And so what this was is a small step towards trying to create alternatives whereby it was recognised that putting a company into administration and liquidation was creating significant and almost irreparable damage to companies that were in financial distress, and that there were experiences and examples of companies that were going into administration which may otherwise could have achieved a restructure through an informal restructure like Safe Harbour. So that was really the reason why the legislation was introduced back in 2017. Look, the law provides a mechanism to protect directors from personal civil liability for insolvent trading whilst they go through the Safe Harbour process. and later and during the course of the presentation, we will talk about what those steps are. The great thing about the legislation is there's a lot of flexibility around the way that the actual Safe Harbour process is approached. You don't have regimented timetables and structures like the voluntary administration. There's a lot more flexibility that allows the actual company, its directors and its advisors to prepare a restructure that suits them based on a timetable that better suits them as well. And there's a lot more flexibility in that sense in terms of trying to save a business that's in financial distress. It doesn't provide relief to directors from criminal liability for insolvent trading. That's a much more severe provision of the Corporations Act. It's not something that you see commonly, but it usually is linked to those directors that are actively trying to avoid paying their liabilities, usually tax or Phoenix activity, and that's where the criminal element of insolvent trading often comes up. I would say from a practical and reality perspective, the person that's entering into Safe Harbour is going to be a different persona to those individuals that are actually actively using companies to avoid having to pay tax. They're not the kind of people that would be wanting to engage in the Safe Harbour process because their motivation is obviously to not pay tax. So I don't see any sort of overlap or concern around conflict there, around the lack of relief therefore under the Safe Harbour rules. Just on to the next slide there, Kira. So one of the key elements of the Safe Harbour is that you need to ensure that you qualify for the process. So what they call is the eligibility criteria. It's fairly straightforward. What it is that you need to make sure that your tax applications to the company are up to date, make sure your lodgements are done up to date, and that was an eligibility criteria, as I understand it, the ATO were quite keen to have inserted into the law at the time, which is pretty typical of them. The obligations to employees, including superannuation, and Mark's going to touch on that in a couple of slides' time around some of the intricacies and interesting issues that are coming up with the employees at this present time. Around underpayments and etc. So those entitlements must be paid as when they fall due. The company must have up-to-date records to show that the financial position of the company is accurately reflected. So one of the things that we see as insolvency practitioners in liquidations is that we have to undertake an assessment as to whether the books and records are compliant with the Corporations Act. And so what they've done here with Safe Harbour provisions is to basically ensure that everyone's books and records are accurate. Again, if you look at it from a very common sense, practical perspective, it's very hard to restructure a company if you don't have accurate books and records, because you actually don't know what you're having to fix if the accuracy of the financial position is not actually being reflected in a true position. So in that sense, a lot of them, that bottom criteria would weed out companies that don't have proper record keeping. Again, I do question whether those kind of directors are going to be entertaining the thought of Safe Harbour when they can't even maintain their own books and records. So that's the eligibility criteria. The way that you commence the Safe Harbour process, again, it's not very prescriptive or clear in the legislation how it is commenced, but generally speaking, if the board passes a resolution to invoke the Safe Harbour process, that will be taken and accepted that the Safe Harbour process has commenced, provided the eligibility criteria has been met. And I would recommend as a process that you clearly document all that process leading up to invoking that process. And the reason why one of the reasons why the eligibility criteria was put into place was to make sure that there was no abusive process from these illegal Phoenix operators. Again, I think it's a less important point, because generally speaking, if someone is serious about wanting to restructure the company, they are generally tax compliant and compliant directors, not breaching their director duties by undertaking non-payment of certain creditors. So again, you're attracting the right kind of directors in wanting to explore this opportunity. Just to cover off here, once the process has been agreed, certain actions like standstill agreements with financiers may be required, and a strong and transparent communication approach. Later in the presentation, I'm going to run through a very useful and helpful slide that the Turnaround Management Association has put on their website around the process. I'll talk in a little bit more detail just around the around that process and things such as standstill agreement and the communication process and what should be achieved there. On to the next slide, Kira. So over to Mark.
Thanks, Simon. So from a practical perspective, if you're an accountant and you've got a client that says, oh, look, I'm having trouble paying bills, or I'm going to have to structure the payment of my bills, or I'm worried about solvency, etc. As soon as the director starts to suspect solvency issues, that's the time to reach for the Safe Harbour provisions and to start to look at, should you be developing a plan to get into Safe Harbour. So as Simon said, this is only a protection for the civil provisions against insolvent trading, which are among the most onerous in the world. It doesn't apply to the criminal provisions. So say in the Clean Maid case, that director, Andrew Young, got a 9-year sentence for defrauding Westpac, and 3 years of that was for insolvent trading.
I'm sorry, I've just got a couple of a couple of comments that say that I can't hear you. You might just have to speak up a little bit.
Okay, thank you, Kira. I'll move closer to the microphone. I was saying that as soon as the director starts to suspect the insolvency or to suspect there are solvency issues, is the time to reach for a restructuring plan and to seek to activate Safe Harbour. So it's really important to get prompt advice as soon as that suspicion of solvency issues starts to arise. I pointed out that, as Simon had said, the Safe Harbour doesn't apply to criminal breaches of the insolvent trading provision. And I cited the Clean Maid case, which resulted in a 3-year prison sentence for insolvent trading. In that case, employees were owed $3 million, but Westpac was owed $29 million. And for directors that are more diligent, one of the key things to start with before you even look at Safe Harbour is, are our employee entitlements being paid as and when they fall due? Because that's a key ongoing requirement to be able to stay in Safe Harbour. There's no use jumping into Safe Harbour if you immediately get pushed out of it because of a lack of compliance. And the test is whether or not, if you're failing to meet employee entitlements, whether that failure is less than substantial compliance. So where do directors get tripped up and get advised that they can't get into Safe Harbour? Firstly, if you've got employee contractor issues, so if you've been treating employees as contractors contrary to law, when you get proper advice on that, that can actually preclude you from being in Safe Harbour. It's a real systemic issue in the business. Second of all, if you've got persistent underpayment issues, this slide pointed out, even companies with great programs such as Woolworths, Wesfarmers, ABC, Qantas, they've had systemic underpayment issues, and they can, if they are systemic and result in less than substantial compliance, they can push you out of Safe Harbour. I gave an example on the slide of Kiki K. That entered into administration in March 2020. It was brought out of administration in June 2020 by Aaron Condon Designs. Then they got pushed back into voluntary administration in August 2021. And the question is, well, why didn't they go into Safe Harbour? And the administrator's report showed that employees were owed $2.2 million. So the key issue for directors is, if you're in financial trouble, don't shortchange employees, including their superannuation. Seek to ensure that they're paid as and when they're due, because failure to do so might preclude Safe Harbour, and then you've got to look at a formal appointment. Thanks, Kira. Next slide. In terms of superannuation, the ATO has released some statistics that I've shown on the slide, showing that there's a...
I've still got a couple of comments saying it's muffled.
I'll point the laptop toward me. So we're sorry, we're pushing Simon out of the slide. So the ATO has estimated that superannuation shortfall is about 3% or 3.8% now of the total superannuation that should be paid. So that means 4% of companies at least are just not paying superannuation as and when they should. And for those companies, they can't look at Safe Harbour where it's a systemic issue. So again, as soon as a company puts their hand up and says, look, we've got solvency issues, it's a priority to look at the super position, look at the employee position, and seek to address that if they're wanting to get into Safe Harbour. Thanks, Kira. Next slide. So in terms of when a client should consider using the Safe Harbour provisions, as I said, as soon as the director starts to suspect insolvency, or even if they're doing their cash flow forecasts and they anticipate future issues, that's the time to start looking in depth at these provisions. If there's an impact such as COVID, will come later that there are COVID relief provisions, but any external event that causes a cash flow shock or that is expected to produce one in the future. And thirdly, if the client believes that they may already be trading whilst insolvent, that doesn't preclude them from reaching for a Safe Harbour plan, but it obviously means that the need for advice is urgent. Thanks, Kira.
Okay, thank you. So it seems like it's a laptop issue according to some of my people online, so hopefully it's better. I'm on the right side of the speaker, but so the next section we're talking about is how is the Safe Harbour engagement structured? The interesting thing about it, the great thing about the law is it gives a lot of flexibility as to how you structure the team, how you go about it, as long as you comply.
It's also breaking in and out, Simon. So if you want to point the laptop to you, mate.
Yep. Is that better now? That better?
Perfect.
Sorry. Welcome to the world of the new world of presentations. But look, there's no set rules. Look, it can involve a restructuring practitioner, a legal advisor, and the board. It can involve a turnaround advisor. It can involve a turnaround director. Generally speaking, I think as a minimum, the board should be actively involved. Absolutely, they can't just abdicate themselves from it. And secondly, lawyers, a legal advisor should always be there alongside, not only just to manage the Safe Harbour, but look at the legal elements of the restructure, the director duties, obligations, and all the various aspects that go along with that. And certainly from an implementation, that restructuring practitioner or turnaround expert that gets engaged will play that role, which is around the financial position and the implementation of the plan together with the board. But I do see the Safe Harbour process, certainly the ones I've done, the reason why they have been successful is because it's not because we had one person doing the actual work, we had a team. Or we had a team of individuals that involved all those, from the lawyers to the board members to myself, in that process. And each of us were very aware of what we could add value to. Make sure that the actual Safe Harbour advisor is appropriately qualified. We'll talk a little bit about that when we get to one of the future further slides down towards the end of the presentation. Now, what I've done here is I've just done a little bit of a outline as to sort of the practical approach here. So there is investigations and analysis to undertake to determine what that course of action is. Every company is going to have its own problems. If we go back to Mark's earlier comments about KKK and its employee entitlements, that might have been a key driver around doing the analysis. It might be that there's too many sites on a different business, and how do we consolidate those sites down to a smaller number because the cost of leasing or the cost of those premises is actually weighing on the business. It could be that there's a problem with the customer base or the creditors. So every company will have its own particular issue, and it's important to make sure that analysis highlights the actual issue, problems, not just come out with some generic comments as to what needs to be done. When preparing the report, which is on the better outcome assessment, make sure that it outlines that analysis, make sure it outlines what that appropriate course of action is. And that course of action is very important, because you can get that. That's where it can, if you get the wrong course of action and you do nothing about changing the wrong course of action, then the safe harbour process will fail. So having some acceptance that you need to change and pivot and undertake different things during the implementation of the process, you have to be aware of that as well, because accepting it from the beginning that this is the right action may not necessarily be the correct approach. The course of action must be a better outcome for creditors than going into external administration. So the report would generally outline what the course of action is, what it looks like for creditors. Ideally, the outlook is that creditors will all get paid in full. It might be that there's some steps taken to reduce the headcount for employees. It might be that there are steps taken that you're changing creditors or suppliers. But generally speaking, the safe harbour provision will usually aim to have all creditors paid in full. So trying to make it look better than administration, it's not generally that difficult to do, because an administration means that you're insolvent and you can't pay the creditors in full. But if the actual safe harbour process is not realistic, then it's not successful, and then you do ultimately can end up into an administration or liquidation process. The better outcome assessment falls under 588GA7 of the Corporations Act, and that is, it provides a view, that view that it's a better outcome than liquidation or administration. Now the plan is to review. Sorry, the slides have just cut off there. I'll just go to the final slide. Yep. So the plan is to, the plan is reviewed and presented, and then it's agreed upon between the advisors and the board. So one of the things I experienced, certainly in the safe harbour engagements I was involved in, is that there were lots and lots of meetings, regular meetings, and regular questions. The ones that were, thankfully, all three that I did in the last 12 months have been a success. But what I found with those three that were a success is that the difficult questions were being asked. People weren't just accepting that the course of action being proposed by the CEO or by the advisors was the right approach. They were asking the real serious and proper questions to make sure that the plan was realistic and achievable. Kira, just on to the next slide. Now, just in terms of the plan, I think it's an absolute that you have to have timelines agreed upon, and articulating what the process of that implementation is. It should address all elements from operational, strategic, and financial issues. There might be, when I talk about the legal elements and contractual commitments, that certainly falls within that space. The financial space will explain the position. It will be used to make sure that it is actually achieving an outcome that is in the best interest of the business. So tracking the financial performance throughout the whole safe harbour process is extremely critical. And simply just looking at how the forecasts are right at the beginning, making sure the forecasts are realistic. If they're not, revising them, and then using that revised forecast as a way forward to make sure that the actual safe harbour plan is achieving what it wants. I mean, what we are trying to do is we're trying to save a business from failing. Then once we've achieved that, and then we look at restructuring, then we're trying to make that business thrive. So it's really important that basically the financial review and performance during that period of safe harbour is extremely at the top. It's at the top of the list, and it's a priority for the business when they're undertaking the safe harbour process. One thing that's not clear under the legislation, and I think it's a good thing, is that there isn't a time period espoused. Now, if you look at an administration, they give you that time period. You can get extensions. It's directed by the court, but you are still always subject to a time period. One thing that the plan should be doing is defining what that time period is for that business, but be prepared to change that time period if it makes sense. And so it gives you a lot of flexibility throughout the process to be able to tweak things, change things, but make sure that that tweaking and the changing is actually for the best interest of the business, and the business can actually come out of the process without having to go into administration. And so when I mentioned there, the board should carefully monitor the process. Meetings should be held regularly. And the main thing too is identify who your key stakeholders are. Now, if you have a secured creditor in the bank, absolutely, they'd be one of the key stakeholders. But your key stakeholders could be a certain group of employees. They could be a certain group of trade creditors. They could actually be the tax office. Now, the tax office might be a key stakeholders because they might have the largest debt. They might be agitating the most. They may have even taken a secured position in a payment plan agreement. So again, the transparency of the process to those key stakeholders is important. And how you disclose that to the stakeholders will differ based on the situation. Again, you've got to understand the sensitivities between the company and that stakeholder. And then you develop a messaging that ensures that the stakeholder is feeling like they're kept informed, but balancing out as to how transparent that you want to be. Later on, we'll talk about the survey that ARETA did, and you'll get a sense of, certainly for the members of ARETA, what they saw the Safe Harbour and whether it was successful or not. So just on to the next slide. Now, what we have here is the Turnaround Management Association is one body that the restructuring industry is actively participating. I'm a member of the Team A as well as ARETA. They have developed this table here, which is a fantastic table on explaining the Safe Harbour process. Now, I've already mentioned a lot of this throughout the presentation already. I'll go through it again because this is the most important slide. And for those that are on the call and they're wanting to better understand the process, looking at this slide as a starting point is a very good starting point. And I think to Team A's credit, they've done a very good job here. And I didn't want to reinvent the wheel simply for the sake of reinventing it. So you can see they've split it into 4 parts, or 4 phases as they call it. Again, we'll run over some of these things again, but they call the first phase starting to suspect it. So this is where the mindset of the director says, hey, I'm in financial difficulty. Usually the way that is driven is that basically they've continued to miss their budget. They're continuing to see margins shrink. They're starting to see regular months of losses. And so therefore the director's getting concerned about the financial performance of the company. It might be that it's been driven by a legislation change. It might be because it's been driven by a contract being lost. It might be driven because there's a rise in cost of materials or labour hire costs. So whatever the reason that drives the business into a situation where they're not meeting budget, their profits are being missed, or there's no profits at all, that's when the director has an obligation of the Corporations Act to make sure that they're not trading whilst insolvent. And as we said earlier, we have some of the strongest insolvent trading laws in the world. And so there is a real proactive obligation on directors to make sure that they're avoiding insolvent trading. And when we go down to the steps available, as the Team A calls it, what you have here is that the directors have formed an initial view whether the company is solvent or is at risk of insolvency. Now, I would hope that directors, when they start to use and implement the Safe Harbour, they're starting to suspect that there's a risk. They're not saying, oh, I'm insolvent, right? So coming back earlier in the risk cycle of a business and trying to predict and have that conversation with a restructuring practitioner, their accountants, their lawyers, and saying, I'm feeling like we're heading towards a trajectory of insolvency, not coming in and saying, I've actually been insolvent for 6 months now. The success of the Safe Harbour process will be much stronger if they're coming in a lot earlier in the process. And this is why when you look at the eligibility criteria of maintaining books and records, you see that the reality of it is that anyone that is wanting to entertain Safe Harbour will generally be coming in a lot earlier in the process, will have very strong record keeping because they are starting to suspect the insolvency. Now, for those practitioners that are online today, we've had many conversations where you meet a client, you sit in the meeting, and they go, I want to put myself into Safe Harbour, and their director penalty notice is expired, or they've been running losses now for 15 months. It's just not possible, or they haven't even kept their lodgements up to date. So generally speaking, the conversation gets held in leading into a liquidation or something, but generally speaking, they rarely qualify for the safe harbour process. So for those that are actually getting into the process, you'll find that they're a much better quality business in terms of its operations. So the other thing too is that once you are looking to consider entering into the safe harbour process, the mindset about incurring debt needs to be considered carefully. All right, so you need to make sure that you're not incurring fresh debt that is not being incurred for the purposes of achieving a safe harbour restructure. So what I'm saying there is, if they're still considering safe harbour and appointing a safe harbour advisor, that mindset of being very cautious about incurring fresh debt should almost start prior to the appointment of the safe harbour advisor anyway. It's really important that directors document the process. Make sure they're doing proper board meetings. Make sure they're doing proper file notes. But I think it's also important that documentation is also being considered with proper legal advice as well. Make sure that the documentation is accurate and reflective of what the process is. One point that gets pointed out here by the TMA is looking at the director's insurance position. It's an interesting comment because most D&O policies now exclude insolvent trading. But there are definitely policies out there that basically have that protection. They certainly have a protection for breach of director duties. So I think there is no harm in looking at the insurance position. Whether the actual insurance position provides a protection is really debatable. And I certainly have in recent years found it less and less obvious in D&O policies that the insurance trading clause is not an exclusion. Now, moving into the assessment stage and entering into safe harbour. So the first one is we talk about this appropriately engaging a qualified entity. Now, if you look to the right of this, and I appreciate it's quite hard to read this slide, but what TMA defines as an appropriate qualified entity is someone that has expertise in the operational, management, financial, legal aspects of a restructuring, a tertiary qualified person in turnaround. Okay, that includes someone that may be qualified in the ARETA course or a TMA course that's been done, has a demonstrated turnaround and restructuring experience, has got compliance with the Code of Ethics accredited by their organisation. So if they're a chartered accountant, whether they're a member of TMA, whether they're a member of ARETA. Again, you're asking that question because you get the quality of advisor usually comes along with it. And what's included in that is a restructuring practitioner or an insolvency practitioner. They sit automatically within that appropriately qualified entity because they've already had they've already obtained their registration. They've already had ASIC approved that they've got sufficient experience to act in that role. And whilst the mindset of being a liquidator is very different to the mindset of being the safe harbour advisor, there are many aspects that are aligned in terms of creating the right experience. But again, as a board member or as an advisor to a client that's in financial difficulty, make sure that you question the experience that advisor has with respect to undertaking safe harbour. Make sure that the eligibility criteria is met. We won't, we talked about that in depth earlier on. And make sure if there is any officer or employee misconduct, and usually there is, you act on it very quickly. Now, if that means that there's a process that has to be taken by making it happen in the safe harbour process, then fine. But again, if the steps are to remove a person that has caused the financial problem, and that's the better solution, then do that. But again, it comes down to a commercial judgment at the time as to what the best steps are. But if you've got people that are causing the problem and are the main instigators of creating the financial performance issues, I would recommend you to seriously think about removing them as part of the process. Make sure the advisors form a view on the availability of the safe harbour. So leading up to that, to appointing the safe harbour advisor, make sure you're getting advice as to whether the process is right for the business before appointing that advisor. Again, what is recommended, and whilst it's not espoused in the Corporations Act, is that we basically passing a board resolution seems to be the most practical way of dealing with that. And you look at the evidence outputs at the bottom there, and for those, you know, what it does talk about is making sure you document things properly. Now, moving on to the course of action. So now we've appointed the Safe Harbour advisor. We've got the team in place, and I do highly recommend you have a team of advisors and board members and key management. You then work to develop a plan. That could be that there has to be steps taken to enter into a standstill agreement with a secure creditor. There might be, and you should really check whether there are covenants in funding agreements that requires you to disclose to your secure creditors that you have actually entered into a safe harbour process. There is some conjecture as to whether, for those that are listed, as to whether that you need to disclose the safe harbour process with the ASX. I think the view that has been taken here by the TMA that you don't, but you certainly, that's a decision that is made by the board, and it should be made in conjunction with appropriate legal advice, particularly those that have expertise in disclosure requirements. Again, disclosing it can be a negative because it's public, and it may create a scrutinisation similar to what we see in administration. And sometimes if we're distracted heavily on having to comply with the public expectations over the right expectations for the business, you know, the right people are getting taken away from doing what is needed to be done. We talked about the team. The TMA calls it the turnaround committee. Whatever you want to call it, you can call it that, but you need to have a team of people that are prepared to play a role and play a very active role. You then implement the process. One of the key elements of the process will be looking at managing cash. Cash is absolutely key. You hear it all the time. You hear terms like they call it cash stabilisation. Whatever the term is, it's about managing cash, being very cautious with what you're spending, being very focused on what you're actually generating, and making sure that you are keeping in place sufficient cash. And the plan should cost out what it's going to cost, what the process will cost, and whether there needs to be further monies injected, or whether there's, and how that's structured. And so cash is key in all these processes. And make sure you get stakeholder approval. Now, for those key stakeholders where you've got a key trade supplier, or whether you've got a very strong employment base with a strong influence over the delivery of your product or service, you need to keep these people involved so they feel like they're on board to implement the process, and you're being properly transparent. Now, the final step, the final stage is once you've done the analysis, once you've worked out the plan, you actually have to take the steps. And many times I've seen where I've sat down with directors that ultimately appoint me as liquidators, and they said, we did a safe harbour process. I said, great, show me the plan. Yeah, we did a plan and nothing's documented. Right, okay, so what you have is a convenient excuse that you've gone into safe harbour when really you haven't, right? For a business that is truly wanting to implement the safe harbour process, you've got to have that plan. It's got to be well documented. And again and again in this slide, certainly in the commentary and what we've said throughout this presentation, the documentation of steps, the documentation of the approval is paramount. So make sure that people are basically documenting the process, then make sure that the steps are being taken, and then make sure that those steps, that those people that are responsible for taking those steps are being made accountable. And that's where managing the key stakeholders, maintaining appropriate financial records is very important. And again, throughout the whole process, all the general law and statutory duties are required. Make sure that you're compliant. Now, one of the unfortunate things is that creditors can still commence proceedings against you. You can't stop them from commencing proceedings. So one of your key stakeholders may end up being an agitating creditor that is owed a debt. And how do you manage them or stop them from issuing a winding up notice? So again, work out who are those key stakeholders. It might be that this creditor that you may not even use anymore could be holding the life or the future of the company at ransom because of the fact that they're able to issue a winding up notice. So again, you may have to put in some sort of ex gratia or payments into the restructure process to stop those stakeholders from agitating or creating the failure of the process. And look, what I said earlier in the presentation, make sure that you're prepared to change the course if necessary. Okay, we're all not, you know, we come up with a plan. We have to accept that the plan needs to be able to transition, to change, to be agile. So make sure that you do that you're prepared to change the plan, and make sure throughout the whole process that you're asking the question, has this been a success? Is this working? The financial performance is always usually the indicator of it and the accountability tool, right? But it might be many other things as well. Short-term financial success might show that the Safe Harbour process was great for this year, but it may cause issues next year and the year after. So the mindset has to be short-term, you know, primarily, but at the same time looking at the medium and long-term benefits as well. Okay, so it's a bit of a balancing act. So again, we mentioned at the bottom of the evidence outputs are around the board minutes, progress reports and monitoring reports. And again, that's where you start to use your advisors. And I think the thing that the important consideration here is that whoever's involved in the Safe Harbour process, whether you're the advisor, the lawyer, the restructuring practitioner, the employee, the company or its directors, it is a commitment. It's a big commitment, and it's a commitment that everyone should be prepared to invest in. Okay, this is not a part-time thing that you do. The company's in financial difficulty. It's staring down a potential insolvency either at some stage in the future. We're trying to reverse that and change the course there. And so again, to do that, it is not an easy thing. Okay, on to the next slide, Kira. All right, so look, very simple thing in concluding the process. Once it's been implemented, the board needs to reassess the position and certainly the financial position and ensure that it has improved and achieved what the process aimed to do in the first place. If the actual process has not been achieved, then you may have to invoke that formal insolvency option. So again, being realistic about this. Directors are protected from insolvent trading during the Safe Harbour process, provided it's been done properly. And so the thing is, if you get to the end of the process and that process has not been a success, the director's obligations to avoid insolvent trading are still there, and they need to invoke the process of appointing an insolvency practitioner. Now, ideally, we hope that that doesn't happen, because if you look at the objectives of the legislation when it was introduced, it was to try and avoid that process in the first place. Okay, on to the next slide. Over to Mark.
Thank you, pointing the camera my way. So this is just a very brief slide to say that when a Safe Harbour advisor is appointed, if the lawyers are appointed first and then appoint the Safe Harbour insolvency practitioner, that can assist to preserve privilege in the advice being obtained, where the advice that's obtained by the insolvency practitioner is being provided for the sake of giving legal advice on the status of the Safe Harbour. So there are different ways to do it. Sometimes the insolvency practitioner is appointed first. We've assisted both public and private companies in relation to these appointments and Safe Harbour reviews. And so we recommend that the legal advisor, where possible, appoint the Safe Harbour insolvency practitioner. Obviously, the protection of privilege is not absolute. You may have seen that the ATO has been confronting members of the Big Four firms, saying that they're using the cloak of privilege just to disguise advice that shouldn't be subject to privilege. So it is a matter of controversy. Privilege can be lost in certain circumstances. So it cannot be assumed that all of these analyses are safe from discovery in due course. So it does mean that the appointment process should have care about it as well as urgency. In relation to Simon's comment about the listing rules, the ASX has clarified in Guidance Note 8 that they don't necessarily regard the appointment of a Safe Harbour advisor or the engagement of a Safe Harbour process in and of itself to need disclosure under Listing Rule 3.1. But they do then hasten to add, though, that the extenuating circumstances that have triggered the need for Safe Harbour should still be considered for disclosure under Listing Rule 3.1, as would normally be the case. So, for example, if you lose your major contract of your major customer, and that provokes a Safe Harbour advice and process, the loss of that major contract, of course, needs to be considered for disclosure under Listing Rule 3.1 as a development that could materially impact the share price, just like any other major development. Thanks, Kira. Next slide. So, in theory, it is possible for a company to go into Safe Harbour now, even if they've been insolvent since COVID started. And that's in theory. And the next few slides I've produced are just a comparison of 3 different Safe Harbour processes that are now in the legislation. One of them historic, relating to COVID, just so that you can compare and contrast the different outcomes and the different eligibility criteria. I'm not going to go through all the slides in detail. The middle slide, the middle column, which is COVID Safe Harbour, only applied for debts incurred during March to December 2020. And that was relatively easy for companies to get into. So effectively, the regulatory regime turned off the insolvent trading liability regime at a civil standard for debts incurred in the ordinary course of business necessary to facilitate its continuation during that COVID period. So a company may have been trading whilst insolvent during that period, and if the debts aren't incurred or the failure to prevent insolvent trading is not dishonest, then neither the civil or criminal provisions would apply, and then the company could then move on to consider Safe Harbour protection. I say that they could look at this in theory because the eligibility criteria remain, say for example that employee entitlements are being met, or there's substantial compliance, super's being met, tax filings are up to date, etc. So there may be some companies that have just been bumping along the bottom of their trading history during COVID, and now they're at a crossroads thinking, well, things aren't getting better even though the economy's opened up. They shouldn't assume that Safe Harbour is not available just because they've had a persistent problem, but they do need to really look at those eligibility criteria. And if they don't satisfy, if they can improve the eligibility criteria points so that they do qualify, they can then tip into Safe Harbour. For smaller companies, they also have the option of the small business restructuring process that applied from 1 January this year. And I've put the criteria for that, and that's for liabilities, total liabilities that don't exceed $1 million. And the benefit of that restructuring process relative to Safe Harbour is there is a moratorium on enforcing director guarantees. And so all of these 3 regimes are effectively debtor in possession processes with different levels of support from a restructuring practitioner or from a appropriately qualified person. And so we just recommend that if you're an accountant with a business in trouble, you look at each of these 3 to see, well, what is the position in relation to what's happened last year, what's happening this year, and do we have small business available, or are we going only for Safe Harbour protection? One of the other points that, one of the eligibility criteria that we haven't quite touched on is that the directors need to be taking appropriate steps to ensure that any misconduct by not only directors but also employees of the company that could adversely affect the ability of the company to pay its debts are being prevented or addressed. And that, say for example, we had a client recently that had some motor vehicles that were the subject of debts, and the motor vehicles went missing in the middle of the night. And so for companies in Safe Harbour, there is a question about, are you taking appropriate steps to protect and safeguard assets against dissipation? Not only dissipation through phoenixing activity, but also dissipation through employee misconduct. And even these misconduct claims could involve, sexual harassment claims, any other misconduct that could adversely impact the financial position of the company or its ability to pay its debts. So these sort of sleeping issues, these misconduct episodes that we see played out in the press, they can also impact the ability to be in Safe Harbour. So I don't propose to go into detail on all those slides here, but I can answer questions on those three regimes if anyone has some questions. Thanks, Simon.
Thanks, Kiro. Can we just go to the next, I think it's 2 slides away. So just for those that are online, you'll see that there's a fair bit of detail there to look at from what Mark just talked about. If we just move to the next slide there, Kira. So I just thought it'd be useful just to talk about what's happening at the moment in the world of Safe Harbour, because the government's undertaking a review around the laws to see if there needs to be any changes made to the process. There's been a number of submissions made by colleagues within my industry, and certainly by bodies like ARETA, CMA, and accounting associations around the success of the process. One thing that ARETA did is that they reached out to the members and asked us to put in some responses around what we thought and viewed the laws were like, and how successful they were. One thing that was very clear in the process was that it does seem like the Safe Harbour process works for medium to large businesses. What seems to be apparent is that the directors value the issue of insolvent trading, or the breach of insolvent trading, much more seriously than those in the smaller businesses. They put that more up the top of the group of priorities than maybe the directors of small businesses. For those that are in the small business space, and when I say small business, we're talking turnover of less than $1 million. Those directors have now got another option, which is the small business restructuring process. It's a very light version of an administration, but generally speaking, those businesses in there, the issue of insolvent trading is secondary to things like personal guarantees, being locked out of the premises, what's my credit card debt, more or less sophisticated issues that apply to them in their business. So the other advantage, and what was mentioned in the survey, was that it did legitimise an informal method of restructuring. Again, it was good to see that the legislation allows a lot of flexibility and a lot of ability to change the course and to make sure that things can change as required without necessarily having to run off the court for a court application or seek creditor approval in a formal sense. So again, but it did also allow the informal process to be legislated. So there did seem to be a view that the promotion of Safe Harbour was still insufficient. Look, I'm a bit mixed on that. I think what we're starting to see is certainly a bit more acceptance of the process. Yes, it's taken longer for potentially the business owners and the market to engage with it as quickly as what we all hoped it might do. But again, because of the flexibility in the legislation, there had to be a period of testing, seeing what could work, and learnings from engagements to enable it to go out. We certainly have people in the market, and we all as restructuring practitioners are finding we're doing more and more of this work in more recent times than certainly when it was introduced in 2017. Sorry, I'll just get my slides here. Yeah. So the go-to thing cuts it off. The one thing that the Safe Harbour does do is it gives the option of privacy. One thing that is very obvious, certainly having acted in roles as administration, is that it's a very public process, and it's open to anyone, certainly the media, to publicise it, and publicise it in a way that's not to the benefit of the business. So the great thing about Safe Harbour is it can be done in relative privacy, and that those key stakeholders are being advised accordingly. So it certainly then protects the brand. So one comment that came out of the survey, which was a bit interesting, was that the appropriately qualified entity definition could open the way for accountants and clients to use less qualified advisors. Now, it's an interesting comment that's made, because at first instance you think, well, it's a little bit self-serving by the members of ARETA to say that. But at the same time, the psyche of the actual board member in trying to enter into Safe Harbour is already established, in the sense that they're actually trying to save the business. So if they are genuinely trying to save the business, why would they go off and engage an advisor that's not appropriately qualified? I think the question that's probably better put in that situation is to say, what are the kind of questions that you want to be asking the appropriately qualified person that might be sitting in front of you to make sure that they're the right person? And questions like, have you done a Safe Harbour role before? What's your experience around financial performance? What's your operational experience? Looking at that slide that the TMA had put there, asking questions as to, and testing them out around their knowledge around the process. This is how you get to a situation where you're much more comfortable that you're actually engaging the right person. And again, it's no different to when you have a legal dispute, you're trying to work out which is the right kind of lawyer that I want to engage. On to the next slide. So where this submission process is at the moment, they're really just trying to work out whether they need to make any further reforms, or whether they're just getting a sense of whether it's been a success. So generally, it seems like the Safe Harbour provision has achieved its aims, and that is it's giving financial distress companies the opportunity to remain viable, and some breathing space to allow the restructuring to occur. And finally, just in terms of directors, usually seek Safe Harbour advice early enough, and to make sure that they're not being too entrepreneurial, right, about the financial position. Okay, be realistic about it. Okay, don't be trying to sell yourself or convince yourself that basically, because I'm in Safe Harbour now, I've solved the problem. No, that's just the start of the problem, of solving the problem. The solving of the problem is implementing the process, the plan that you put in place, and seeing the financial results triggered from that. And one of those steps might be that you merge, or you actually sell businesses or parts of the business, or you actually do end up going into administration. So I keep using the word be realistic. Be realistic about the use of Safe Harbour. Okay, so on to the next slide. There's a couple more comments here. Again, we mentioned about SME directors being more concerned about personal guarantees and their tax. We do have firms that do specialise in this. Generally speaking, most restructuring firms have some sort of experience in this, and we are starting to see that directors and boards are becoming more familiar with the process. You know, associations like the Australian Institute of Company Directors, they publicise a monthly publication, and in there we've seen a number of articles that talk about this process. We haven't seen too much misuse of the provisions. And there has been some challenges to invoke the Safe Harbour because there's been a lack of financial resources. So again, if you look at all the qualifying criteria, some of these responses are fairly expected because the criteria, resolves that. And look, it's one of the comments there: insufficient consideration by the courts of the Safe Harbour provisions. However, we haven't seen too many situations where, when the Safe Harbour defence has been put forward, has it actually been considered a proper defence. Again, it's very difficult. I certainly haven't seen it come up in one of my administrations yet, but I think we'll start to see that process, that defence come up more often. Now, I'm conscious it's 10:59. And so just onto the next slide there. There's a couple of quick points there, Kira, and that was just the, there was some reluctance around doing the actual safe harbour because the formal insolvency is more lucrative. Again, it's a little bit self-serving from the members. I think what matters is that you get the right advice for your business, and certainly having a discussion on safe harbour is always worthwhile during the process of looking at your options. Okay, so just moving on to the next slide. That concludes the presentation. Apologies for the noise, but this is the first webinar for the firm, and really thank you all for coming along. I don't know, Kira, was there any questions that came up?
No, not at the moment. I haven't seen any questions pop up.
Great.
But if you have any questions, please feel free to email. Happy to respond and provide further advice without being on the clock to just answer any questions you might have. If
we just go to the next slide, Kira, that's our contact details. Feel free to reach out to either Mark or I. But thank you very much for those who attended the very first session of the Cathro Partners webinars, and it's great. And I was getting nice text messages during the process as well. So thank you very much, and look forward to either catching up with you in person or attending the next webinar, which will be sometime next year. Thank you very much. Cheers. Cheers.